Coastal Resources Management Council to order. Today is Tuesday, January 24, 2023. I'd ask that the record reflect the council members that are present, as well as the CRMC staff that is present as well. First matter on our agenda will be approval of the minutes of the previous meeting, that being Tuesday, January 10, 2023. I would ask for a motion to approve the minutes as presented. So moved. Motion's been made. Is there a second?
Second.
Motion made and seconded. All in favor, say aye. Aye. Anyone opposed? Motion carries. Any subcommittee reports?
There actually, there's one subcommittee report, Mr. Chair. We just met the Rights of Way subcommittee meeting. Subcommittee just met to give a status report on two specific rights of ways that are under review, being the Spring Street extension out of Westerly and the Buttonwoods matter in Warwick. And it was just a status for the subcommittee. There will be more status and updates for the subcommittee in the future. But that's it for subcommittee reports, Mr. Chair.
Okay. Any staff reports?
There are no staff reports tonight, Mr. Chair.
Okay, which brings us to application which has been before a subcommittee and is before the full council to receive the subcommittee's report and recommendation and deliberation and action on the final decision. That application being 2017-12-086 Harry Grasso. An application to establish a 3-acre oyster and bay scallop farm using floating and suspended gear in Potter Pond, Narragansett, Rhode Island. I am going to ask Attorney DeSisto at this time to present to the council the posture of the case and our proceeding for this evening.
Yes, this matter was heard by a subcommittee over several hearings with about 33 hours of testimony. We have some of the subcommittee members here on it. I know the rest of you haven't. Before we begin on this, I would like the members that were not present on the subcommittee to state on the record that they did review the transcript and the record and are ready to vote on the matter, deliberate and vote on the matter. Is that a fair statement for everyone?
Yes.
It is.
Yeah.
Yes. Okay, the record should reflect that all of the members present were either subcommittee members or have reviewed the transcript of the record, all of the documents, and are ready to take the matter up at the council level.
Yeah.
Further, Mr. Chair, there was a request from the applicant for the introduction of newly discovered evidence. I don't think that we're going to need to hear arguments from the various parties on that. A review of the regulations in regard to this matter, specifically 650 RI RIC R20-00-1.1K. This is not something that would have been discoverable. Rather, it appears to me to be a settlement proposal, so to speak, and therefore is not something that the council should consider or make part of the record at this time. But I would ask that a motion be made to that effect.
I would move that, having read the document and looked back at the history on this, I think that this is just too late to come in at this particular meeting.
All right, a motion has been made by Mr. Gomez, seconded by Mr. Sahajian. I will call for a roll call vote. Mr. Izzy?
Excuse me, I have a question.
Yes.
So just to be clear on what this motion is based on, is it based on, where's Mr. Gadman? Hello, hi, Don. Just Gomez, I'm just curious. Can you just clarify the basis of the motion? Did you say it was because it was out of time?
I think that we've put a lot of hours into this, and that this has come up. There were many opportunities. We did a study on several reconfigurations. The one that was recommended by CRMC was different than the one was applied for. We moved things back and forth and took lanes out and tried to make for what it came down to was that it was really was a lot of public use there. And it was a dangerous spot for even sailboats to come back through into that particular cove. So it was just so well discussed after so many hours, and I was part of that, but it just seemed to me that this is just too late. I mean, we've already had that many bites at the apple on reconfiguring it, removing it from shore, and just cutting lanes down, different options on the actual outlay of the and it's a fairly small oyster farm. My opinion was that we just don't need to see another one. There was plenty of time, and it was well discussed in the past. So that's where I'm coming from.
And you're
And you know, when you're kind of coming in at the last minute with a Hail Mary is kind of the way I'm looking at it. I guess you'd have to be Catholic for that.
and in your clarification was that it's a settlement offer and not
What's that?
Attorney DeSisto. Your advice to us was that it's coming in as a settlement offer more than evidence.
Well, under section 1.1K, new evidence is that which is of a material and controlling nature and not by the exercise of ordinary diligence discoverable in time to be presented at the evidentiary hearing. So rather than being evidence, and I agree with what Mr. Gomez has said, but my own view and the advice to the council is that it doesn't qualify as newly discovered evidence and therefore should not be accepted or considered by the council.
Thank you.
Mr. DeSisto, I think I'm going to withdraw my second because I disagree a little bit with Don, and I think that,
You have to speak up a little bit. I'm sorry.
I'm sorry. I would like to withdraw my second because I disagree a little bit with Don, but more importantly, I think that the regulations indicate that we cannot take new evidence if it was readily available at the time of the subcommittee's hearing.
Correct.
Correct. So I think we're getting off onto a tangent, so that I'm not comfortable with. So I withdraw my second. And I think we should stick to the attorney's advice and focus on the regulation. If we're going to deny it based on the regulation.
Well, can I just ask a question, I guess, of council? You've had a motion to deny the introduction. And then some rationale for the motion. A second for the motion to deny, maybe with some different rationale. I don't know if the rationale matters. What we have before us is a motion to deny and a second to deny. Am I correct?
Yes, but I think the concern is that to make sure that the record is clear on it. And I don't want to tell you how to vote or why to vote, but I think that's the issue. And I think that's why Ms. Hall had her question. I just tried to clarify it.
Well, my question then is, if there is a second to the motion and we vote on it, am I correct that we're not voting to incorporate the rationale? We're incorporating we're voting on a denial.
Yeah, my only concern is for the record purposes, the findings upon which the motion are based. So if the second is withdrawn, you have a motion now that's not seconded, and if it doesn't get another second, I think another motion would be appropriate.
Okay. Is there a second to Mr. Gomez's motion? He fails to get a second.
Mr. Gomez, would you consider making a motion based on what the attorney advises on?
I made the motion and I'm sticking with the motion that I made. I just feel that it's coming in too late. It's just an attempt to keep delaying it, the hours and the meetings and all that we had, and I did read through, and I'm not sure I can bring it up with this decision document that's on the agenda tonight. I read through that. And I kind of agree with that. So I just think this is a very bad time to bring it in. And what are we going to do?
I agree.
Discuss it for another meeting, hold
I
it
agree.
again, another subcommittee, and then wait for the next configuration? I mean, you sat through
I agree.
all these meetings and you saw what we did and tried to be extremely fair. And arrived at the conclusion it was a dangerous spot for, sailboats and people on skis and a whole bunch of things. So, I mean, I've never, that I can remember, voted against the northeaster lease since I've been here, like whatever, 12 years or something. And that's kind of my favorite subject, right? The lobstering's going away and the fishermen have to do something, and it's great. But I think it's a bad spot, and therefore I thought we discussed it to the end, but I understand, the legal position of it. I just don't want to withdraw my motion. If nobody wants to second it, then you can, vote denial, move denial, and we'll go through a roll call.
All right, there has been no second. Is there an additional motion?
I move that we deny the opportunity for the new evidence based on Attorney DeSisto's recommendation in the regulations.
Is there a second?
Second.
Motion made, motion by Mr. Sahajian, seconded by Mr. Gagnon. Any discussion? Hearing none, I'll poll the council on that vote. Mr. Izzy? Aye. Ms. Hall?
Aye.
Mr. Gagnon?
Aye.
Ms. Reynolds?
Aye.
Mr. Sahajian?
Aye.
Ms. McGovern?
Aye.
Mr. Gomez?
Aye.
And I too, Raymond Coyer, vote aye. So that's that. And you like to continue with the posture and proceeding this evening.
So this matter, as I said earlier, was vetted extensively at the subcommittee level. You have the subcommittee decision. You have the transcript, the record, all of the documents that were submitted. You've all taken a look at it. And at this point, again, by statute, specifically section 46-23-20.4 A, the matter is in order for deliberation at this time. So I think it's appropriate to deliberate, discuss, and make the appropriate motion on the subcommittee recommendation to deny the application.
Mr. Chair, can I ask Mr. DeSisto a
Yes.
question? Can you hear me? Tony, compared to the recent Barrington aquaculture farm that was denied here and appealed to Superior Court and overturned, would you consider this similarly situated?
Not in terms of location. But that was an application that was denied by the council, actually. And recently, the Superior Court overturned that decision.
Okay.
And that was an aquaculture lease, an aquaculture lease. It was in Upper Narragansett Bay off of Nayet Point. I believe it was a 2-acre lease.
Okay.
In that matter, the staff had recommended approval and it was denied.
Okay, thank you. Mr. Chair, may I have the floor?
Yes, Mr. Sahajian.
I am
please.
not advocating by any way to approve this application as submitted. For a starter, the floating devices, aesthetically are just unpleasing, and at the very least, we would owe neighbors and residents or citizens of Rhode Island, the fiduciary not to have something unattractive like that. But a couple of things that stand out. Number one, with the Barrington aquaculture getting overturned by the Superior Court, I think we have, like a slippery slope here. there's a chance, okay, based on the fact that Dave Butel wrote a staff report that's favorable to this application as submitted, right, who's the aquaculture guru of the Northeast, okay, based on the fact that the town harbor master indicated there wouldn't be any navigational issues, testimony in the record. There's a chance if we deny this, the Superior Court could overturn it and the entire 3 acres could get approved. So that concerns me. I think what we have to try to, well, my position is I think what we have to weigh out is what would happen or where, I shouldn't say what would happen, where would the applicant, at what level not appeal? If we approve 20%, would he appeal and maybe win and get the entire 3 acres? If we approved half. So I really think that we have to, think critically, because 2 or 3 years from now, if we deny it, once again, based on the evidence, based on the staff report, based on the harbor master, the entire project could get approved, which I think would be a travesty. Okay, so I'm just sharing my thoughts and concerns. I did some math. Okay, if what was presented, if we reduced it by 39%, okay, it would be a rectangle, approximately 175 by 460. Okay, it would be, the reduction would be from sea to land, okay, which would be an additional 50-foot buffer. And Mr. DeSisto, one other question. Are my personal experiences on that pond relevant?
Under the case of Restivo versus Lynch, if you can articulate the basis for your personal knowledge, yes.
Okay, so I'm familiar with that area. I live in Narragansett. I've taken my son tubing in that area. As presented, I feel there's enough room there, but reducing it a third, affords even more room. So once again, based on the evidence, based on Dave Butel's staff report recommending approval of the entire project, based on my personal experience, based on, and I have some notes, page, I think 77 in the transcripts, where the harbor master indicates that there would not be navigational hazard as presented. I think my reduction, I think is fair. It definitely meets the burdens in the red book. And once again, Dave Butel's report indicates that the entire 3 acres met the burdens in the red book. So at some point I will make that motion, but I, want to hear from everybody else. Thank you.
Well, I just want to ask Mr. DeSisto something first. If you can enlighten the council as to our ability to modify the schematics or the footprint on the application. I understand what Mr. Sahajian is saying, so I'd like to know our ability to do such.
Okay, I'm looking at 46-23-6. Subsection 2B. The council shall be authorized to approve, modify, set conditions for, or reject any such proposal. And that's for applications.
Have we ever done that in the past?
Yes. But also specifically in regard to this situation, this type of a situation, in 46-23-20.4, the council may in its discretion adopt, modify, or reject the findings of fact and or conclusions of law of a subcommittee. However, any such modification, rejection of the proposal, findings of fact, and conclusions of law shall be in writing and shall state the rationales therefore. So,
Have we ever done that in the past?
yes.
I'm sorry, I just wanted that I interrupted how you were finishing, but
No, I'm all set.
okay. Mr. Gomez.
Yes, my biggest concern was involve safety. And I was kind of on the edge with it when we were talking about kayaks and paddle boards and skiers. And I thought that they could adjust to that. And we did try different layouts, removing a lane, changing to a polygon instead of a rectangle or a square, and move things off the beach more. And none of them was satisfactory, but the nail in the coffin for me was when one person or multiple people came up and talked about sailboats going in and out of that cove, and the rocks associated with coming in, especially if you have a blow on or you have to take a certain direction to come in. And just not enough room to navigate a sailboat, not a big one, just recreational type sailboats in and out, and especially in, and avoiding the corner markers and the field. So that's where I came across, and it was really a safety issue versus anything else. I mean, we tried very hard on the subcommittee to accommodate a layout that would be satisfactory. And I know Dave, and I know his original layout, and we determined as a subcommittee that layout would just not do it. And so we moved on from Dave's recommendation and tried to find additional alternatives. And they were either unsatisfactory to the applicant, or they were for various reasons, or to the people that were against it. And it was the safety issue, especially sailboats, like, the paddle boards and kayaks, they're pretty capable of staying out of trouble. But skiers, well, if you want to be stupid, I guess you can be, and we got down to 2 and 1 and how often. And so that was really iffy, but the sailboat question really stuck with me. So that's my input.
I was on the subcommittee, and referring to your statement that we tried to, or made suggestions as to alternatives. My recollection is that we tried to move it outside of the original footprint. Put it somewhere else, put it on the other side, bring it over there. So my read or understanding from Mr. Sahajian is you've got the original footprint and you're just bringing it in from there. You're not moving it outside or anything like that, correct?
Correct.
Okay. So I see that a little bit different. As I said, I was on the subcommittee. I did have an issue with the full set of the 3 acres, the way it was. I learned a lot about water skiing over that and turning radiuses and the like. I did have some concern for that, but my concern was, as the footprint was presented in the original application, I listened to many of the opponents / objectors and their arguments, testimony, concern as to the safety if it went out as far as it went out. But with some modifications, as Mr. Sahajian has indicated he may incorporate into a motion, I think that's something I could support, because it will alleviate some concerns of the objectors, but also afford Mr. Rasso, the applicant, an opportunity to do what he asked to do. Yes, Ms. Hall.
Thank you. I want to address first this Barrington decision. And just to be clear, is that Judge Kehoe's decision in April of 22 that you're referring to? Is that the decision that you're referring to?
Then that would be the one, correct? Yes.
And we don't have that decision, the facts of that case before us, nor do we have the law before us. But a quick read of that decision seems really inapplicable to the matter before us, because the Superior Court's review of that focused on failure to provide an opportunity for cross-examination. That's not an issue in this matter. And secondarily, failure of the record to adequately reflect that all the evidence at the hearing that was presented was adequately considered by the council. That also is not pertinent or relevant to this case. With respect to the ability to modify, of course, there is the authority to modify, but I just want to raise two issues. One, modifications of pending applications, which this is not necessarily in the review period, but under Rule 1.4.12, we have a provision where the executive director has the discretion to set a review fee if the modification is submitted after the staff reports are completed, which really gets to the issue of the fact that there is actually a substantive review that has to be done by the staff. We wouldn't have a review fee if there wasn't the need for a substantive review. So first, I feel that a substantial modification, and in this case, 39% is a substantial change, would require staff review. We even have a fee for a review. Secondly, under our rules 1.5 with respect to notice, 1.5.1a talks about completed applications, formal applications relevant here, that there's an array of people that get noticed in the area or areas so affected by the proposed activities in accordance with the APA. And in that light is the issue of notice. So even where we have a review fee, we also have the issue of public notice. And in this situation, guided by the Administrative Procedures Act in particular, and also by Rhode Island law, where changes are substantive, which is more than minor, we have an obligation to uphold our, under the APA, the transparency that's required is to have public notice of something that's more than minor. Otherwise, we more or less nullify the entire public notice process. Interested parties, whether it be the municipality or those that are regulations, all those that are in areas that may be impacted, they lose their opportunity and they're precluded from that opportunity to attend a public hearing where they might have had an opportunity to participate. They might have had an opportunity to weigh in on the application as submitted, and they don't have that opportunity if we do a more than minor change at this juncture. So I'm very compelled by Rhode Island law, and certainly the idea of this jurisdiction that this council has, which is public trust, submerged lands and waters. I mean, we are held in trust for the public, and to not have notice of a 39% change, or however you do it, it's not minor. It's more than minor, which is what Rhode Island case law says, and that I think that's concerning, and I don't think that's something that we have the jurisdiction or the authority to do.
You want to respond to that? This is stuff.
Well, all good points, of course. But section 1.4.12 states that when an applicant or his or her consultant submits a redesigned site plans for proposed activity after staff reports have been completed. So this circumstance isn't that, because this isn't coming from the applicant. I think what's happening in the deliberations is that Mr. Sahajian is proposing a reduction on the existing plan. So this major change is lesser than what was originally proposed. So the question becomes whether or not that reduction, that smaller amount, warrants going through a hearing again. And I'm not, that is definitely a policy consideration. But I do think that 1.4.1 two is not applicable here because it's not coming from the applicant. This is deliberations from the council. The analogy would be somebody proposes a 200-foot dock. The council approves it, but only at 170 feet, that type of a thing. A few weeks ago, you approved an application where the dock actually moved off of where it was, same size, just in a slightly different location. And I think that's what needs to be discussed here rather than that issue. And I'm not, believe me, that's something that you all have to decide. I'm not telling you that, I'm just trying to give you the outlines of the law.
Yeah, I think it's not so much that it's on point exactly, it's that it's analogous to the idea that when you make a change, the point is that there is the need for staff review of that change. If it's more than minor. And for us to, a major change, whether it's less or more, it's not, it's not a flat landscape, it's not, we're not changing the contours of this desk. We're talking about a marine environment that has a lot of variables that I'm not sure we're equipped to really assess as a council. That's really something the staff has to do. So that was my point. I agree that it's not exactly on point, but I think it's analogous to the idea that we're not voting on a changed size of a tabletop. We're voting on a major change, whether it's bigger or smaller, it's not the point, it's not minor, of a marine ecosystem that is something that is a variable that we're not the experts. They are, the staff is the experts.
I think that's definitely the issue that needs to be deliberated. You're correct.
Thank you.
Mr. DeSisto, am I correct that Mr. Butel at the time of his testimony was a staff member?
No, he came back on this one. I think he had retired, but agreed to come back to testify in his report.
At the time of his review? Was
At
he
the
a
time of his
staff member?
review, yes, he was a staff member.
Okay. And he reviewed and gave an opinion on a 3-acre footprint, correct?
Yes,
And am I correct that he was of the opinion, and I think the record reflects it, that he had no objection to it?
correct.
And what we're doing is reducing the 3-acre parcel that he reviewed and gave the opinion that he had no objection to it. Correct?
Yes,
Okay, so I understand what Ms. Hall is saying. In her argument that maybe staff needs to review this, but we're not moving it, it's just shrinking what was already opinion that there was no objection to, so I don't think it's necessary. Myself, I'm comfortable utilizing the extensive record that we have and the prior, well, not the prior, because he still holds it, the expertise of Mr. Butel and his prior testimony. Yes, Mr. Gomez.
I feel that I concur with the presentation given by Ms. Hall down at the end here, but and we're fighting through some of the legal issues here a little bit, I think. But I think the real slippery slope here is that when this council decides that we can arbitrarily pick a dimension and what's its configuration, rectangle, trapezoid, polygon, what is it? And we just start putting that down. That's the slippery slope, because at that point, well, let's try this, let's try that. The applicant, hasn't even gotten up to say, gee, I agree with that yet, or that type of an issue. So I support the idea that it would need to be reviewed by, if we propose a new layout as a council, I feel that the staff needs time to review it and come back to us.
Mr. Chairman,
Wait, I just ask a question, Mr. DeSisto, and follow up to Mr. Gomez's comment. If Mr. Rasso is not pleased with the decision here this evening, he has the ability to appeal it. But the
Yes.
applicant can appeal it, correct?
Follow-up question to that.
Yes.
Do the interveners also have the ability to appeal?
Yes. Yes.
So it's a good chance this is going to be appealed one way or the other. So to me, I think we
Yes.
should just stick with the subcommittee's recommendation and let the chips fall where they may after. I mean, we don't even know what the plan looks like in terms of reducing it. I don't know what it looks like. I don't know how it would work with what's going on out there. And there's, we said there's been no chance to have staff review or public input, so I'm more comfortable dealing with the staff, be a subcommittee recommendation and making a decision on that, and then the things move forward after that.
Mr. Chair.
Yes,
I have the
Mr.
floor.
Sajan.
So at this time, based on all the evidence in the record, based on the staff report, based on the fact that Mr. Butel is aquaculture guru in the Northeast, based on the town harbor master indicating the 3 acres would not cause any navigational hazard, I move that we modify the application and we reduce it by 39%, I'm sorry, and we approve 80,500 square feet, okay, which would be inside of the footprint that was originally presented, which was approximately 130,000 square feet. We eliminate all the floating devices. That's my motion.
I'll second that.
The motion has been made by Mr. Sahajian, seconded by Ms. McGovern. Any discussion? Yes, Ms. Wall.
I agree with Mr. Gagnon in that we don't have a sense of what this application looks like under those contours. You know, doing some simple mathematics regarding this ecosystem is inapplicable to the mandate given to us by the legislature and under our own rules and regulations. And this idea of eliminating floating devices, I mean, that's a change of aquaculture gear. We have not, no one, staff has examined a change in gear for fisheries in aquaculture. And we're going to decide that that meets the requirements under the rules and the regulations under the mandate from the legislature. I don't think we have that expertise at all. And so I just would like to raise the fact that this is really getting into the weeds on aquaculture design, ecosystem impact, user impact, impacts we can't really contemplate given no information whatsoever other than dimensions.
Mr. Chair, may I speak on my motion?
That's discussion, yes.
So once again, the professional staff recommended approval for 3 acres. Okay, my proposal reduces it by 39%. So when someone indicates we don't have the professional ability to make that decision or determination, I rely, and we should all rely on the evidence in the record and the staff report as presented by Mr. Butel for a 3 acre expansion
With floating devices
with floating devices
that he reviewed.
that he reviewed. Thank you.
Mr. Chair.
Yes, Ms. Reynolds.
I was also on the subcommittee and sat through extensive hours, and my primary concern was safety. Mr. Sahajian, could you just explain, and I understand this is a subset of what was already approved, that it's included in that same footprint, and as such, I think it was part of Mr. Butel's review and approval. How did you determine that sort of very specific amount, 39% of a reduction? Where are those numbers from? And does it have anything to do with what might impact safety? And how many acres is 81? How does that compare?
It's just shy of 2 acres. The original application was for 3 acres. So basically 80,500 feet is just shy of 2 acres. And I brought it back 175 by 460 to pick up about an additional 50 feet of buffer from the water towards the land, which I thought would address any additional safety issues for water skiers. And once again, the town harbor master said as presented, wouldn't be any navigational hazard, but I just scaled it back even more, for abundance of caution.
Any further discussion?
Yes.
Yes, Ms. Wall.
I have some further questions to your questions, which I think are excellent regarding your calculations. So we don't have a picture of where this is. It's east, it's west, it's south, it's north, somewhere in that configuration. And you're saying that based on your opinion, that would resolve some of the user conflicts. And also you refer repeatedly to Dave Butel's staff report. He did not review a project that looks like that, nor did his review. And I don't know, I didn't see anything in the record. And I'm looking at his report relative to him reviewing this with the different gear that you're now talking about. So when you say it's based on the expert in this guru of New England, and I respect Mr. Butel deeply, I think we're bound to the record. And I don't think the record reflects that he reviewed an application without floating gear. That doesn't mean there's no gear. That just means there's floating gear. There's no floating. So what gear is replacing that? No gear, less gear, more gear? I'm just wondering if you can clarify that, because I'm not seeing that in the record.
The underwater gear would replace it.
Yes, Mr. Gomez.
The proposal, as I remember, the applicant was looking for multiple shellfish types. There was some bottom planting of clams or cohorts or something along with the oysters, and it was critical on water depth. And so, you know, under the proposed 39% reduction, is that out in the deeper water where it poses more of a hazard for the sailboats and things coming in? Does it come closer to the shore? I think these questions need to be answered by staff. If we propose just a reduction, it's in a certain footprint. And you haven't stated what the footprint is, 20 feet offshore, 100 feet offshore, the water depths and things like that. So I still think we're at a point that this is a slippery slope. And that if we propose such a change, I think staff really needs to look at it. And Dave was right 99.9% of the time. This was one of the last he did, and I believe the review, he was not on staff when he came in. He just came in to support his presentation, and that original layout was immediately, which I believe he ended up with a trapezoid of some sort. I think that was immediately rejected, and we started the big discussion on where and how many rows and how many feet off the beach and water depth, so that we could do multiple shellfish layouts and things like that. So I think there's just too much going on here to approve. Let's just reduce 39%. I think it needs more professional review. If in fact we would have moved Mr. Shagan's motion.
Are you more inclined to vote to approve the 3 acre as presented?
Me, no, absolutely not.
Mr. Chair, I move the question.
Can I ask a question?
I'll withdraw that.
When you were discussing the modification, Mr. Sahajian, you indicated that the shell bed area would move over 50 feet. And I assumed that it would move over 50 feet landward.
Correct.
All right, so to Don's point, it's not just a 39% reduction
But
in the original footprint, it's 39% reduction, bringing it down to the approximately 2 acre area and moving it 50 feet landward from where it was original.
and
So-
that's not the motion. It's just to reduce it by 39%.
right.
Not to move it landward or, position it.
Inside.
I think
Not included.
I said landward.
Did you?
Yes.
I'm sorry, Jerry.
Sorry.
Mr.
Mr.
Chair,
Dwyer, move the question.
okay, one last question.
Yes,
I'd like to ask Mr. DeSisto, would it be viable for us? I am supportive of the idea of finding a compromise solution for this, but I am concerned about public safety. If this is something that could actually be put on paper and drawn so that we can actually see where this would be and staff might weigh in on it, and then we could hear it after that. And so we have more information to have in front of us about what this actually looks like and how these changes would be actually put in place, and then have that come back to the council.
That's. I assume that would be in the form of a motion.
no, I mean,
There's
the
a
motion,
there's
a second, we're in discussion.
There's actually a pending motion now. So I think you have to vote on this motion first.
Yeah. All right.
And it could be susceptible to a further motion if approved. If it isn't approved, then another motion could be in order.
Correct.
The motion has been made and seconded, motion made by Mr. Sahaj and seconded by Ms. McGovern. I will now poll the council, Mr. Izzy,
Aye.
Ms. Hall,
No.
Mr. Gagnon,
No,
Ms. Reynolds,
No.
Mr. Sahajian,
Aye.
Ms. McGovern,
Aye.
Mr. Gomez.
No,
I too vote aye. 4-4.
That's a 4-4 vote. So the motion fails. Is there another motion? Because another motion's in order.
For another motion,
I'd like to make a motion that we consider the revisions as proposed by the earlier motion, but actually have this reviewed by staff and come back to council with the staff opinion about the reduction.
second.
I'm sorry, can I
I'm sorry,
Yeah,
I
get
asked
that.
council a question.
get the
Either
term
her
of that
or
motion?
you want.
I'm sorry.
Read it back.
Can we just, I just need to get the terms of the motion.
I'd like to make a motion that we consider the revisions as proposed by the earlier motion, but actually have this reviewed by staff and come back to council with a staff opinion about the reduction.
Have a new plan.
And this would include a plan.
For the staff to review.
There was a second,
I just, I have a question.
We done.
oh, I'm sorry, Don, you seconded it?
I did.
Okay. Discussion, Ms. Hall?
So for clarification, are you saying then that they would submit a revision to the staff, an actual revised plan for staff review as part of ongoing negotiations? Is that what you're suggesting?
Not the applicant, but I think that it would be possible for Mr. Sahajian to put this on paper with what you thought this might look like.
Wait, so what's his expertise at that? Does he have expertise at that? Do you do this for a living? It seems like that's something that should be done by somebody. I mean, we have a lot of regulations about who's qualified to submit plans. Wouldn't that be something?
Mr. Willis, can the staff prepare a 39% reduction in the footprint that was submitted by the applicant?
We can do the math. We can cite a 39% reduction within that footprint. But the caveat is it exactly what you tried to describe tonight? I wouldn't.
Moving it landward. 39%. Can the staff formulate 80,000 square feet in the original footprint going landward?
This is the system, please.
I have a procedural question for the moving member. Patricia, are you asking that the matter be referred to the staff for a report on the prior motion?
I think just this discussion actually shows the problem. How would the applicant know where to put this if we can't even decide where it should look like on paper? So I think somebody has to put this on paper so that we can take a look at it and review it. And I think that it's unreasonable to expect the applicant to know how to build or construct this if we don't even know where this might be. So I don't know how to get to that point at this, but I think if staff would be able to give us something that conforms to what we are considering so that we can see what it looks like and an opinion on that, that's what I'm looking for. No?
Mr. Gagan.
I had an idea.
I guess, in addition, if that was to happen, we would also need, I guess we'd be saying that they would have to use bottom gear, which would mean we would need some kind of assessment of the marine environment and the impacts from bottom gear on the marine environment, which I think is getting to be a little bit more to ask of staff than they normally would do with a project like this.
Haven't they already,
Kind of hesitant to.
hasn't staff already, I guess I'm asking this out loud, but hasn't staff already given an opinion on the bottom gear?
It was the proposal was floating gear.
No.
Mr. Getch.
Thank you. There was a survey done on the bottom of this site, the 3-acre site, as part of the review of the preliminary determination. That information was used when the application was considered by the Marine Fisheries Council. So there has been an assessment of the bottom that was not only done by CRMC staff, but also by DEM. And I believe they used their Venturi device to actually take bottom samples, looking for the presence or absence of shellfish such as soft-shell clams and cohogs. And it was also noted that there was no eelgrass found in that area.
Statement. Hey, Mr. Willis, please.
And just to follow up on both comments, if the council directed staff to take this information back and try to address the 80,500 square feet, 50 feet off to the east, we would look at those natural resource issues with the data that's on the record in the file already. And we'd have to take that information that's already been part of this discussion at the subcommittee level and now here again to address Mr. Sahajian's footprint within newly revised footprint within the original footprint. I would take that information that we already have, try to address those issues.
So and I'm sorry, but the motion would be then, as stated, but it would be a referral to the staff for a report with the evidence that's already in the record for a report on the proposal in the prior motion. Is that what is basically, that's the motion?
Yes, that's the motion.
I think Mr. Gomez, you seconded that?
Yeah, but okay, we need to get into some little bit more discussion because we haven't detailed what the area is. There was Butels was the original recommendation. Are we talking inside of that? We had several discussions that led us to a different configuration relative to the layout, moving it in and out, but keeping the original square footage intact, and the desire of the applicant on, some deep water, some shallower water, that type of thing. So unless we say or ask the staff to either recommend where it goes, or if we say, well, it's going to be a rectangle, it's inside of Butel's original, which was modified from a previous one, I believe. So we really don't know what we're trying to fit this reduction into. I don't know what that area looks like. I don't know if it's a rectangle. We haven't voted on any of that. Subcommittee looked at it. They changed the original layout to a more amenable configuration as opposed to the original stretched out, pointy areas to try to accommodate 20 feet along the shoreline and things like that. So we don't have a configuration in hand that we would apply this reduction to. We don't know what that is because we haven't voted on the fact finding and the decision on what the area, what we looked at is more of a denial based on safety, but we don't have an area to look at unless we go back to the original application, which is a highly irregular shape. So just something to consider, you know, so if we do this motion and we need to allow the staff to pick a compatible dimensions on the reduced area based on conditions of bottom and whatever, but within the original proposed area. But you know, if it needs to be a rectangle instead of this other trapezoidal thing, let the staff decide that, in addition to trying to just fit a smaller thing in a configuration, because we don't know what that configuration is unless we go back to the original area requested or approved by Dave.
Ms. Hall.
So I have three, I guess, questions for you, Mr. DeSisto. One is that thinking forward, if this matter were to be sent back and having the staff somehow draw or design the elements of this revision, the burden of proof in all of our applications is on the applicant. So in a decision-making role on a contested case, you know, shifting that responsibility to the staff doesn't seem in line with our application procedures. And so I guess that's a question to you, is that, does that trigger a concern relative to down the road, assuming some kind of an appeal, we have before us a design that is not submitted by the applicant who's got the burden of proof to prove that the design meets the standards. So I'm wondering about that, number one. And number two, I'm also wondering about relative to our role, as you articulated, reviewing a subcommittee report, the findings of fact and the conclusions of law and the 147 letters of objection and the numerous public hearing comments that are part of the record that we reviewed and very clearly make findings based on all of that are not based on different gear. So I wonder if our role then changes in terms of reviewing that subcommittee decision when the findings of fact now are not in alignment with the record. And although the staff would review it in line with what's the review that's been done by staff, it's a different project. So I'm wondering how that impacts our role relative to these findings of fact and the conclusions of law, because we weren't at the hearing. And then third, I'm wondering if you can advise regarding what the Superior Court has said before regarding public notice and substantive changes that are more than minor, that it usurps the political, the public participation role by having modifications that are greater than minor. So I'm wondering if you can advise the council on those 3 points.
Well, it's a three-part question. And what I'm assuming is that the first motion was made and it failed on a 4-4 vote. And Ms. Reynolds is just seeking to get some council input on a more formal basis when they've had. So the question is whether or not the council has the ability to do that in connection with a report coming in from a subcommittee. And assuming that, and I don't doubt that will be the case, but assuming what Mr. Willis said was correct, that the staff will take a look at what's on the record and see how that fits in with the proposal to reduce the proposal that it is, and make a report to the council on this motion. So the question is whether or not you see a reduction of this nature as a new application. Or if you see it as a reduction of an existing application, but because of the issues that were raised, and I'm not trying to put words into Ms. Reynolds' mouth, I'm trying to interpret what the motion is. That staff input on the proposal to reduce is necessary based on the evidence in the record. And I rely on the case of Wolf versus Wynn. It's a Superior Court case from 2003. 2003 RI Super Lexus 43 as to what the council can do in matters of this nature. And, based on your earlier comments about the relative expertise of the council in matters of this nature, I'm assuming, and I don't want to put words in Ms. Reynolds' mouth, but she would like to rely on the staff's expertise in this area as to whether or not this type of a reduction is something that should be considered by the council, I think. And I'd ask for a confirmation on that. But if that's the case, then I think the motion is in order.
Is what?
The motion is in order, and I'm sorry, I
Okay.
don't mean to turn my back to you.
No, that's all right.
Right.
Well, I'm not suggesting that
Like
it's
this.
not in order. I'm asking for clarification, legal advice to the council to help understand how to vote on the motion. I think it's absolutely in order, but I'm trying to get clarification and I'm not sure maybe I don't understand what you're saying, but I don't think there's any question that there's opportunity for staff to review modifications.
Okay, that's why, by the way, that's why I asked to have the motion read back,
Right.
because I wanted to make sure that I had a proper understanding of the motion.
But my question
Yes.
still is I'll just put aside the objection, put aside the public notice part of the three-part question for a moment, because it seems that we can have this discussion without getting to that right now. I'm still not clear on this notion of staff review. What is it that they're reviewing? I don't know that it's appropriate or in line with our regulations, and I'm asking for you to advise on this relative to the applicant's burden of proof that the staff draw something and also draw it with new gear on behalf of the applicant. How does that impact judicial review later? And how does that impact our role relative to simply affirming or denying or approving or not approving a subcommittee report? So I'll just stop with that first part of the question. I still have the second part of the question that I'll hold until I can maybe get some clarification on that. Will inform my.
May I ask, Mr. Chair, may I ask Ms. Reynolds if what she's asking for is to refer the matter to staff for a report on the prior motion?
Yes, that is correct.
And that would be based on what's in the record that has been developed by the subcommittee.
That is correct.
Okay. And that would be for a view to have the matter referred back to the council for a vote again on Mr. Sahajian's motion.
Yes.
Okay.
I have a question.
I'm sorry. I
How
keep
does this
turning my back.
impact, how does this impact the original subcommittee decision, which we haven't addressed? Is the intent maybe to modify it? I mean, the recommendation was to say no. So we're obviously changing the subcommittee's findings of fact, and well, the findings of fact are the findings of fact, but the decision that they ultimately came to come up with basically a new concept. So should we maybe vote on the subcommittee decision and either reject it or accept it? And if we reject it, then we can move on from there. But I think there's we're adding some confusion. We have a subcommittee report that goes through an answer which you want changed to reduction of an area that we've already with findings of fact and numbers and things. We have come in with a recommendation. Should we accept that now or reject it now? Or just table it. I mean, I don't understand.
This is how I view the original motion from Mr. Sahajian. Under section 46-23-20.4, the council may in its discretion adopt,
Yes.
that wasn't the motion.
Yeah.
Modify, which I believe was the motion, or reject the findings of fact and the conclusions of law. I think the motion was to modify the report. That motion failed on a 4-4 vote. The next motion is to refer the proposed modification of the subcommittee report to the staff for a determination on some of the issues that have been discussed here, but based on the record, that's the evidence that's in the record.
Yeah, okay.
And that's been confirmed by Ms. Reynolds. So
Yeah.
I think that's where this stands now. If this motion fails, then I'm going to ask for another motion just to make sure that the record is complete.
Mr.
But
Chair, I
it-
move the motion.
I'm ready.
I have a question.
Move the motion. That's a vote on it. Have a question.
I still have a question.
Moving question.
I'll second it.
All right, Ms. Hall, yes.
Just to be clear, when you say send it, refer it to the staff, we're referring what exactly to the staff? What are they gonna look at? I just want a clarification. Refer it to the staff. Refer what to the staff?
The proposed modification.
Just so a description by a member of the council that gets referred to the staff. They have nothing to look at.
That's my understanding, yes.
And so no one draws a plan. Staff refers they look at no plan. They look at no information about the new gear. I just want to be clear.
I can't speak to what the staff is going to do.
But when you say refer it, there is no it.
Actually, you got to ask the movement. It's not my motion.
No, I'm asking for clarification. When you say refer it, so we understand, it's just
The question.
an idea. Okay. Thank you.
You're welcome. Okay, motion's been made and seconded. I'll now poll the council. Mr. Izzy. Aye. Ms. Hall,
No,
Mr. Gagnon,
No,
Ms. Reynolds,
Aye.
Mr. Sahajian.
Aye.
Ms. McGovern,
Aye.
Mr. Gomez.
Aye.
I too vote aye as the chair. So that motion passes. That'll be referred as indicated in the motion and discussion. I think that's all that's come before us on this matter, correct?
Yes.
All right, that concludes.
Chairman, before you conclude this proceeding, just for the record, Christian Pizzo, on behalf of the interveners, Kevin Hunt, Alicia Cooney, Stephen Quigley, and David Latham. Mr. Chairman and Mr. DeSisto, I just want to note the intervener's objection to the proceedings just to preserve our right.
Understood. Thank you.
Thank you.
Thank you. Okay, brings us to the next matter on our agenda is public hearing on proposed rulemaking 650-RICR-30-05-01 Ocean State Climate Adaptation and Resilience Fund. Yeah. I just was gonna say that and I'll say I'll wait till they exit. Just that.
quick question. As on the record. This fire department became part of Narragansett. What harbor master? South Kingston and Narragansett harbor master.
Okay. Okay.
Thank you.
Right?
That's all.
Oh, going for it. Oh. Everybody.
Right, back on the proposed jointly promulgated regulation 650-RICR 30-05-01. Mr. Willis.
Thank you, Mr. Chair. This is a public this is the public hearing on proposed rulemaking for the CRMC, who is jointly doing rulemaking with the Department of Environmental Management as well as the Rhode Island Infrastructure Bank to adopt the Ocean State Adaptation and Resilience Fund regulations. This is the public hearing where we accept any comments on these proposed rules. There is no action tonight by the council. The only purpose of this is to have a hearing on the proposed rules and gather input from the public should they wish to speak. We will take that input tonight and at a later date, bring the matter to the full council for an actual vote of the rules to become permanent. But this is just a public hearing to solicit input from the public.
Is there anyone present this evening from the public that wishes to speak on this? Close the public hearing.
Yes.
Public- I'll close the public hearing on it. I would entertain a motion to adjourn.
Motion to adjourn.
Motion made and seconded.
Again.
All in favor, say aye. Aye. Anyone opposed? Motion carries. We stand adjourned.
The applicant is not going to be happy with it. Industrial sites, they don't go through all of this and sealed and it's not useful to us. They went for what we wanted to do before, for a lot of that discussion. All right.